attention. So what's going on, panelists, with Caremark? Are the areas, are the risks changing? What do we think? And I think probably I should let the Chancellor have at least the first word on this question.
Thanks, Jill. As you all know, post-Marchand, Marchand was a recent decision where the Supreme Court found that a Caremark case had been, in fact, well pled. That shouldn't be totally revolutionary, but it seemed so at the time. And I think post-Marchand, the perception was that Caremark was becoming more muscular and therefore more attractive to plead. When you look back at the cases post-Marchand, I think there may be like 14 dismissal decisions since that time, depending on how you count and whether you count them as a Caremark or not Caremark claim. But when you look at the stats, maybe about 4 have surpassed motion to dismiss and survived past the pleading stage. That, to me, isn't scary. that just shows that there's cases out there getting past the pleading stage. But I understand, given the history of Caremark and our repeated rhetoric, that it's the most difficult claim under Delaware law to plead, why people might find it surprising.
I do find it surprising. I mean, I will say, you do see this is the most difficult claim to plead and prove, and for years I think that actually was the case. I think after Marchand, I think we saw, if there's something that is, purported to be mission critical, and then to my mind, there's a little bit of, it's not that hard because there's a little bit of hindsight bias. It's, this bad thing happened, and look, a lot of the Caremark claims that we're seeing, a couple of things happened. Either a lot of people died or a lot of people could have died. And so that's where we're seeing a lot of claims that are actually surviving motion to dismiss. But there's a little bit of hindsight bias almost. It's, this terrible thing happened. I got a lot of books and records. Looks like you guys weren't focused on this. And so I think that's what we're seeing a lot of, and I think that was the case. I mean, certainly in Clovis, Boeing, I think there was a little bit of this terrible thing happened, and had I been there, would have happened differently.
So I can weigh in from the West Coast perspective. People are talking a lot about these opinions, and particularly directors are kind of coming to us and saying, what do we need to do here? Because it used to be the case, and I don't really think it is anymore, that unless there was a red flag waved, you're pretty much okay as a director. I think Bluebell changed that, and there was a suggestion right in the Supreme Court's decision that the fact that the board wasn't made aware of things that management knew somehow meant that the operating systems and the risk management systems weren't effective. So you're failing under prong 1, despite having an audit committee, despite having sort of the normal stuff that you have in place, where I think we used to advise boards, if you've got the standard risk management stuff in place and there's no red flags, you should be okay. And I do think that Bluebell changed that, and you now have to start asking yourself, what in hindsight, right, could I be judged for? And what is my mission critical? What is my, regulatory, or things that, I'd be surprised if Boeing directors thought that an airplane was going to crash ahead of time, right? In hindsight, it seems like, oh, of course, right? Of course you should be looking at airplane safety. Bluebell, of course you should be looking at food safety, right? Of course you should have been doing these things. And a lot of directors are asking themselves, how do I identify that ahead of time? And I think it's particularly challenging for companies here in tech. What are those mission critical regulatory issues? Is it cybersecurity? Is it privacy? Is it some sort of product regulatory issue? There's a ton of regulatory. Does everything need a separate committee? Right, that's where I'm seeing a lot of the challenge.
And that's the difficulty, because now there's a big, post-Marchand, it was should you have a risk committee, and you start talking about what's the risk committee going to do, and then the question I always get is, well, what are they going to do that the audit committee's not doing?
Yep.
I don't know. You fly airplanes. People die. You serve ice cream. People die.
That's his opening statement.
Right? The catchphrase that you're using, hindsight bias, feels so scary. Everything we litigate is hindsight bias, right? I mean, this is what we do. Something bad happens, and someone sues. Criminal law, someone dies, you bring a lawsuit. In corporate law, someone dies, now you bring a lawsuit. And so this hindsight bias argument is I think, just sort of this buzzword that's scary. The reality is companies have to do what companies do. And if you're flying airplanes and you have an entire department and management talking about safety, which is in Boeing, for example, right? Managers knew about the safety problems. Management knew about these things. This is what we do. We fly and sell, we build airplanes and we fly them. If people die, it makes sense that the board did it. It's not enough to just simply say, the only thing a company is supposed to do is make money, so therefore we need an audit committee to make sure that, because that used to be, that was the primary Caremark claim, right? We didn't have an audit committee, and then we built an audit committee. You build a committee for flight safety if you're Boeing. If you are taking in people's information, right, and all you are doing is keeping their credit card information, then maybe that is something that you need to do, which is cybersecurity. Everybody knows cybersecurity is a big problem. If you are selling ice cream and people are dying because you're breaking the law, it's not that much to ask. And it's just really these unique situations where people are dying it is doing. I don't think it's a change in the law. I think it is exactly what Chancellor Allen thought, right? That, yeah, they're really hard, but if people die, maybe they're the right cases.
I hear you, and look, I don't want people to die. Not an objective. But I mean, I guess my question would be, and here's, and look, maybe hindsight bias is a little too strong, but the idea that, is it really board level function to figure out, like, we should have 2 sensors? Like, is that really, I mean, is that the kind of thing that needs to filter to the board, that, the MCAS system was flawed, and so, we've got thousands of engineers working for us, but we've got to bring to the board that, we didn't have a redundant sensor on the other side. Is that really a board level? I mean, how much time are boards going to spend? I mean, boards they're not the ones operating the companies.
And this is what I've heard directors say to me over and over again. I have to be able to rely on management to bring issues to my attention. I don't know what's going on in the business. I don't know that there's this sensor that's going to cause planes to go down. To say to a board, well, I mean, if the issue went wrong, clearly you didn't have a good risk management system in place, that I think gets a little squishy, and you do get to hear that echoed in some of these decisions in Bluebell.
I think the current regime right now is an offensive regime, not a reactive regime. And by the way, good to see you. Happy Veterans Day to the veterans. Thank you for your service. Important day. And by the way, this conference for me will be memorable. We were just escorted through a kitchen. I felt like I was the president of the United States.
I felt like a Kennedy too.
Really, really awesome. So I just want to thank the sponsors for that. So look, I was the trial judge who got reversed in Bluebell, which was a bit of karma, since Bluebell was definitely my favorite ice cream, and I had consumed gallons of it before that case came to me.
And now?
And now I still like Bluebell, I have to say. Even though people eat ice cream, people die. That's the takeaway, by the way. That is the takeaway from our panel. No, I don't want to belittle that. But look, I think what the Supreme Court was saying in Bluebell was there was no board level process for oversight of a mission critical function. Period, hard stop. Give me evidence that you have a system and you're well on your way to beating a Caremark claim. But it has to be offensive. It can't be reactive. You can't get reports of people dying and then create a system. You have to have the system and show that you're mindful of those risks and that you have at least a process. Might not be perfect, might not have worked in that instance, but there has to be a process. And that process, according to the Supreme Court's view, was missing. That has to change now, post-Marchand. So it seems to me that companies, West Coast, East Coast, Middle America, have to, at the board level, assess risk. What are our mission-critical risks? Do we have a system in place to get those risks up to the board so that the board can be mindful of them and, if appropriate, react to them? Still relying on management. Management has to be the source of that. The board isn't in the field, but there has to be a system, a line of communication for those risks to be presented to the board and for the board to do with that information what it sees best in its business judgment. That to me, I think, is the simple message. It is startling because for a while people would see Caremark cases and they would see them come and they would see them go. Even in the wake of incredible, quote, corporate trauma, Citibank comes to mind as a case that was just, billions and billions of dollars of trauma. And that case didn't make it past the pleading stage. Why? Because there was a system. There was at least an attempt there at the board level to manage risk. So I do think it requires boards at this stage to meet with management and to actually identify those so-called mission critical risks, and then to either form a committee or determine whether existing committees are adequate to monitor, quote, oversee those risks, number one. And number two, you've got to document it. What Boeing teaches, in Boeing, what the court said is there was no evidence in any of the minutes of a discussion of safety. And I'm sure at the board level, they were saying, we discussed safety. We talked, we're not oblivious to the fact that our business is putting people on airplanes that fly 30,000 feet in the air, but it wasn't in the minutes. And you've got, the presumption is, if it's not minuted, it didn't happen at the meeting. That is the litigation presumption. And that message came through, I think, loud and clear in Boeing.
Yeah, that was one of the, oh, sorry, Randall.
Let me ask a quick question. If they, because you were talking about how do they know what is mission critical? And if they actually have a meeting and they actually have advisors to say, hey, this is our company. What is mission critical? Hey, we fly planes, probably safety should be, we fly planes, probably, the health and safety of our cafeteria isn't, right? And they go through that and, ultimately they have those meetings. That's going to be a system in place that's probably going to get you past the Caremark claim, saying that, look, we had advisors, our advisors said this wasn't a mission critical issue. We don't necessarily need a committee on that. Doesn't that make sense?
I at least agree wholeheartedly. If you can provide evidence of an effort to identify risk and then to figure out how to manage it, that's a system. Again, it doesn't have to be perfect. The case law is legion. Caremark systems don't have to always work. They just have to be in place. That's the key. And the last thing I'll say on mission critical, this to me is the area of squishy that is problematic. Cybersecurity, for example. I don't care what industry you're in, what product you deliver, what service you deliver. Is it the case that your ability to protect your data is mission critical across the board? I don't know. Mission critical so far has been your product, your service is X. Therefore, derived from X, we're going to say this is mission critical. You make planes, safety is mission critical. You serve food to people, hygiene is mission critical. Is cybersecurity across all of those industries mission critical? That's, to me, a question.
That's the slippery slope, and that's what I think directors here are really struggling with. So cybersecurity is something probably every board is talking about. But is it something where you need to go the next step and set up a committee? I remember the former Chief Justice Strine was asked that question on a panel here in California. And he was like, no, of course not. Not every company has to do that. But in light of some of these cases, might one argue, like Randy, well, if you don't set one up, well, then you haven't been putting an appropriate risk management process in place. I can see those arguments being made by you down the road if something happens.
Of course I'll make it.
That is an important point to remember. So many of these decisions, or so many of these issues draw claims, and maybe, a third surpassed the pleading stage. But that doesn't mean that the court has held that these oversight, channels were inadequate. It just means that the plaintiff pled facts making it reasonably conceivable that people died, and as a consequence, the board wasn't adhering to its duties faithfully. That's different, and has that generated a robust discussion in many boardrooms? Probably. Is that a bad thing? I don't think so. I think it's probably healthy to be having these discussions.
I totally agree with you, and I think that these decisions have spurred on a lot of good discussion. It's hard for directors, though, sitting in the boardroom to really make those judgment calls. To your point, right? What's mission critical? Regulatory, right? That's, the Clovis, if you look at that case. Is that a type of issue where you have to have a separate committee for, or you have to have discussion in every set of minutes? You bring up an excellent point about minutes, right? Which is also a big debate that we've been having between long form, short form minutes. Traditionally, my corporate brethren enjoy doing short form minutes.
Yeah.
It's very efficient, it saves money, right? And it's very difficult to get directors to agree on what happened and what the exact word should be.
If only there was a way to record what actually was said. God, someday we might actually have technology where we could actually know exactly what was said, and then we don't actually have to debate whether or not the minutes were taken or edited wrongly by the lawyers.
We're going to rent warehouses.
I still think that's a bad idea, but I have always been a...
Just like cameras on policemen.
Yeah, but I have always, look, I think, I've been a proponent of long form minutes, and I think a lot of people actually think it's protective to just say discussion ensued, and let's not say, let's not air any of the dirty laundry. And I think there's an appropriate way to write minutes that you can reflect that a discussion occurred. You don't have to necessarily box people into a corner or pin them down, but I think I have been a proponent of long-form minutes. I remain a proponent of long-form minutes, particularly in a process, definitely, but also just generally now. I think minutes are expanding. I think the old school, highly topical is going by the wayside.
Here's why it's a good idea to at least have the discussion. One of the reasons we're seeing more Caremark claims is because we're seeing more 220 demands for inspection. And that litigation now, and we'll get to that in a minute, is fired up fully in Delaware. Stockholders are using the tools at hand to investigate suspected wrongdoing. The level that you want them to begin and end with is the so-called board-level documents. What you don't want them probably getting into is a bunch of text message and email correspondence. So if you can answer the question with a board-level document, then chances are, in the Court of Chancery at least, that's as far as the inspection is going to go, because that's enough. That's necessary, but it's also adequate. Minutes are board-level documents of the highest order, and usually either can be or cannot be very informative on these claims. And so it's a discussion worth having with the litigators and the corporate lawyers, I think.
I would add too, and I know John Mark's been a champion of this for a while, long form minutes can really, eliminate a lot of hassle down the road, even though they might be more expensive and time consuming in the near term. They could save a lot of money and time in the longer term. Also, they should be done relatively contemporaneously, otherwise they will be viewed with suspicion.
And I was just going to say, going back to the point, Kate, that you raised earlier, I think the long-form minutes, I think if you document your consideration of the issues, it really takes the pressure off the board to get its assessment exactly right? You surface the question, what are our emerging risks? What kind of things should we be concerned about? And if the board, in its business judgment, decides something is a low-level risk, and after the fact, with hindsight bias, it turns out that was a problem. The fact that they thought about it, they sought information, and they documented that, that's going to go a long way to establishing the process that the Vice Chancellor was talking about.
Well, that's an interesting question, right? Take Bluebell. If the board determined that food safety wasn't a big issue, we've never had listeria, why would we have to do all this stuff, right? So if you had a couple remarks in the minutes that said, we looked at it, we don't think we need a committee, would that have been enough?
Probably.
Might have been. I mean, I'm not sure, to be honest. I'll defend myself for a moment. The board was, the chief executive and the chief operating officer were on the board. This is a relatively small company, and they were reporting about things happening in the field every meeting, to the point where they had actually authorized an audit of the hygiene practices at the various locations the board had. The problem was it wasn't systemic. It was sort of ad hoc, kind of as it came. There was no guarantee that any member of the board was going to get information at any given meeting on this critical issue, even though they were getting that information. And I said that's enough, but you know, and I appreciate the Supreme Court's guidance. It isn't enough. It needed to be systemic. It needed to be something that could be sort of recreated in the litigation context, where we can see it, feel it, and know that it's happening. And that was missing in that case. So I'm not sure if that's enough, to be honest.
And we'll leave the law students with that uncertainty. I love to leave law students with uncertainty. Before we move away from Caremark, the Caremark cases have put some pressure on the derivative framework. And I want to just take a minute and talk about that and the fairly recent Zuckerberg decision, and ask our panelists their thoughts on sort of how derivative litigation is evolving in response to either these cases or just you know, sort of general developments in litigation practices.
I'm happy to speak to Zuckerberg. I think Vice Chancellor Laster's keen intellect was on brilliant display in that case. He grappled with a history of somewhat incoherent decisions in our law, did his best to explain how it evolved, and restated the test in a workable fashion for judges at the conclusion of his, you know, really masterful discussion. And I think he got it right. Now, would we have all evolved the law that way? If we could go back in a time machine, maybe not. But I think he accurately described what had happened and what the test is that we in fact apply. And that to me is improvement, when we have clarity in our law and the ability to apply it, you know, faithfully. Others might disagree and view it as a C-turn. I do not. I think the Supreme Court rejected that. But you bring up a good point, Jill, and that's that the increasing number of Caremark claims are hastening the development of a derivative framework that's been around for a while, and forcing us to kind of evaluate aspects of that framework that might suffer from doctrinal incoherence. And it will be an exciting time, I think, in the years ahead to see how those issues are hammered out.
Randall.
I think that the... Is it working? I'll just talk loud. It's all right. Not a problem. Look, I don't think that, you know, it changed, you know, Zuckerberg changed the way it was actually being practiced. I believe that, you know, if you look at all the derivative decisions that were coming down, 99% of them were following exactly that framework. I think what Vice Chancellor Laster was really trying to do is say, you know, let's stop sort of getting to this framework without actually having the framework in which to operate. You know, I think that it does, you know, create a problem a little bit as to whether or not directors are really willing to bring a lawsuit against people who were, or that they were involved with in that context, right? If they were just a duke or a duke-care, a grossly negligent and participant in some conduct, are they really going to choose to sue people who were, you know, in bad faith or disloyal in that conduct? And, you know, there was a recent paper, and much of which I don't agree with, but I do agree with the analogy that says, you know, it's one thing for a parent to tell their child not to drink and drive. It is another thing for them to actually call the police on their child after they've been drinking and driving, and yet another thing if they actually provided the alcohol to their child, who then drunk and drive, to call the police. And I think that point makes sense, and I think that's where we're going to have this really sort of challenge between what is bad faith by a director and what is gross negligence. I think that's going to be really sort of where that issue is going to come to light, is like, are we going to say, hey, that was pretty grossly negligent of you to let this happen? Are we going to sort of move that up to a bad faith problem?
But I think there's also a little bit of an oddity. And look, I think the Zuckerberg opinion was great. I think kind of the new formulation is great. I think it does save pages. You don't have to do 30 pages in a brief on whether it's Aronson or Rails, and those are all positive developments. Nobody really understood the second prong really anyway. I think one thing that is interesting, though, I mean, so we have this whole line of cases where if you're a controlling stockholder and you have a transaction with the company, it's entire fairness ab initio, structural bias. And so now we've got, let's just say, controller buys assets from the company. Well, it's entire fairness. So these directors can't be trusted to make that decision. But then if it comes time to sue them, if they're a majority disinterested, well, yeah, of course they'd sue the guy. They just put, they couldn't be trusted to approve the deal, but like, talking about suing them, yeah, we can trust them. So there's a little bit, I will give on that one. I will give it, there's a little touch of a...
I think it just...
I mean, in the Caremark context, no real change, right?
Yeah.
Because it was Rails before, it's basically Rails now, and that I don't think has changed, although there are commentators that say there's more pressure now on the judge to find bad faith with the elimination of the second prong. But the interested transaction, the controlling stockholder transaction, to me, that is where folks will at least argue that there's a disconnect with the elimination of the second prong, and that's where that second prong had some utility. I don't think it actually, I think the existing 3 questions allow you to take on those issues as framed now. I don't think you need second prong to do that. And that dissymmetry or asymmetry that you've identified, I think can be addressed through the Zuckerberg framework. So I at least agree with the Supreme Court. I don't see it as a monumental shift, and it does save some brief pages, I'll tell you, and that's a good thing. Arguing about Aronson or Rails. I've probably lost at least months of my life reading that I won't get back.
It certainly adds clarification. So now that we've relieved the law students of the burden of trying to understand Aronson, which has got to be a good thing, we're going to give you something special in the program. We're going to talk about indemnification. And law students, I know, love indemnification. But there's some new, in Delaware, statutory changes. Delaware's not out first on this one, but trying to sort of clarify the area of indemnification, in part, I think, in response to some of the things that we've been talking about. But John Mark, you've been sort of a key player in this move. Why don't you tell us a little bit about this?
So there's been some legislation proposed, came out of our Corporation Law Council, which is kind of where most of our legislation originates. Went to the Corporation Law section of the Delaware State Bar, and I'm hopeful that it will be considered in a special session of the General Assembly in January. But basically the idea is we're going to amend Section 145G of the Delaware General Corporation Law to allow companies to take advantage of captive insurance arrangements. And a captive insurance arrangement, I'm going to oversimplify a little bit, is basically a wholly owned sub-insurance company owned by the company itself. So for many years, you could always provide, corporations under 145G had the power to, provide insurance, buy insurance for their directors, officers, employees, and agents, including for claims that couldn't be, indemnified. There was always a question as to whether, captive insurance could be used or a captive insurance arrangement could be used. Why is that? So I'm just going to do a little bit of background on how the statute works. So 145 of the DGCL covers all of indemnification. It starts off with Section 145A, which basically says that a company has the power to indemnify its directors, officers, employees, and agents in connection with kind of third-party claims. So direct stockholder actions or claims from third parties. Company can indemnify all those losses, and they can indemnify judgments, fines, expenses, amounts paid in settlement. All of those things, everything can be covered under Section 145A. And then you get to Section 145B, and that deals with actions by or in the right of the company. So we're talking about derivative claims or claims where the board has decided to go sue some poor officer. things like that. And so for 145B, company also has the power to indemnify directors, officers, and others, but only for expenses, and subject to, if they're judge liable, only if the court specifically approves it. All of these subject to a standard of conduct determination that needs to be made. So why is it, though, that 145B is not as broad as 145A? Because if you think about it, the company is actually bringing the claim. So I get a judgment for you. You pay me, director pays me $100. That's the settlement payment. Goes into my right hand. If I were indemnifying for it, I would put it behind my back, put it into this hand, and pay it right back. That's circularity in payment. So for years, that has been prohibited. We didn't allow circularity in payment in the indemnification concept. And that was what gave rise to the question of, well, if we don't allow circularity in payment, can you have a captive insurance arrangement, which is effectively a wholly owned sub of the company? And there are two leading treatises on Delaware law, and they both said, interesting question, no idea. And so now what we have done is we have proposed an amendment to Section 145G. As Jill mentioned, we're not the first state to do this. If it passes, we will be the 9th. Ours will be a little different. The other ones are probably a little more permissive than what we've decided to do. But basically what we decided to do is like, look, insurance, you've always been able to insure for anything, including unindemnifiable claims. I should kind of pause here and also say, part of the reason for all of this, the thought that we put behind this and the initiative, is insurance premiums have been skyrocketing. And particularly after the onset of the pandemic. I mean, they've just really, really spiked. And a lot of our corporate constituents, have been kind of asking for this. And we try to keep our ears to the ground. But in any event, so what we've done is we said, look, you can provide insurance will include captive insurance, including fronting arrangements. But look, there are a couple of things. One, you have to have, the captive itself has to be licensed, and it could be licensed in Delaware or anywhere else. We didn't hometown it, but you have to have a licensed captive. And then the policy itself, the captive insurance policy, has to have some guardrails in it. So we said, like, look, you can't use this to pay for things where people got an improper personal benefit to which they were not entitled, if found in a final adjudication in the underlying proceeding. You can't use it for deliberate fraud. If you've been found to have committed deliberate fraud or deliberate criminal act, knowing violation of law, if that's kind of all found in a final non-appealable opinion, you can't use the captive. Number two, if you are going to use the captive, you have to have an independent party that makes determinations whether to make a payment under the policy. So what we've done is we've said, look, you can have either a third-party administrator, which I think a lot of people do in their current captives, or you can have the same parties that are able to make indemnification decisions under Section 145D. You can have those folks. So who is that? 145, as I was saying earlier, you can indemnify for this and that, but at the end of the day, even if you have mandatory indemnification rights, it's always subject to a standard of conduct. You have to have been found to have acted in a manner that is in or not opposed to the best interest of the corporation and otherwise in good faith. And that determination has to be made by somebody, and so it's usually the directors who are not party to the proceeding, or a committee of such directors if such directors so direct, or independent counsel in a written opinion, or, and I've never seen it, the stockholders. So those parties have to be able to make it, and then if the captive proceeds are going to be used for a settlement, and the settlement would require a court-ordered notice, then you have to kind of make a statement in that notice that, hey, we think we're going to use the captive. So it is, I think this is going to be, look, I'm very hopeful that this does get taken up by the legislature. I think it is a good development. I think the insurance, it's not kind of the same crisis level we were at in what I understand in 1986, or when 102B7 was, underway after Smith versus Van Gorkum, but the premiums have...
Why would that reduce the premiums, though?
So it's actually very interesting. One, a lot of folks are actually self-insuring for their Side B coverage right now. A lot of people are paying more in premiums when you look back 5 years than their claims experience ever would be. And then also
crazy high premiums, double-digit millions of dollars in premium.
The other thing,
it's skyrocketed.
It's skyrocketed.
Yeah.
The other thing too is that, and I've spent the last 18 months or so studying all this, but the way these towers are constructed, I don't know where. It's like Crazy Eddie doesn't price things like this. It's absolutely insane. It's like Tower 1, you could pay $5 million, and Tower 2, for an additional $30 of coverage, you pay $70 million. And then when you get to layer 3, I'm obviously exaggerating, it's hyperbole, but it is a really wacky way. So the captive could actually be used to plug gaps in the tower itself, where there would be otherwise prohibitively expensive pieces, or to cover things entirely. And look, the other thing too is there are some companies that are not uninsured. Well, I guess there's some that are pretty much uninsurable, economically uninsurable. They just cannot get the E&O coverage, or it can't get it at rates that would make any sense anywhere.
And the other thing on this is some companies were getting just side A only to
Yep.
cover for the unindemnifiable loss. And a lot of times you'll be sitting in a boardroom with directors and saying, well, what is that? Right? Okay, well, derivative judgments and bad faith. To your point earlier, what's bad faith these days? A little bit of a changing concept. So you get directors who are like, wait a second, you can't tell me exactly what I need this insurance for. And the side A carriers are going, okay, well, I can start charging up the wazoo for it because the directors are like, well, I need this. So this is really so badly needed. The last 2 years has just been a crazy, scene for insurance. Even side A, the costs I'm seeing are crazy. So I think it's actually going to ameliorate a lot of the tension that's in the system right now.
I hope so as well. And like the retention amounts have gone way up. I mean,
yeah.
it's like there's a real need there's a real need for this. And I'm hopeful that we.
Because Randy keeps bringing lawsuits and charging millions and millions of dollars in defense costs.
Yeah, I think it is super important, and it's a really exciting development. I'm mindful that we have less than 7 minutes left, and Vice Chancellor Slate's sort of previewed the issue of inspection rights and the explosion of cases seeking inspection rights. I do want to turn to that at least for a few minutes. Chancellor, you were going to tell us a little bit about that explosion.
Right, so, it's almost as if stockholders woke up and listened to the advice that Delaware law has been giving them for decades. Like 3 years ago, we've been saying, go conduct pre-suits and a suit investigation, the pleading burden is difficult, use the tools at hand. And starting in 2017, we began to see an uptick in these cases. I think the numbers off the top of my head were around 70 in 2017, and this year we're on target for around 140 cases filed. Those are enforcement actions, so I assume that the letters being sent to boards are far greater and many multiples of that. It might seem like a small number, but just to put it in perspective, that's enough cases to fill an entire judicial officer's docket for a large period of time if all of them go to trial. And not only are we seeing an increase, but they've grown in complexity. We all see that the sorts of defenses you would resolve at the motion to dismiss stage in plenary Caremark claims are being asserted in the context of 220 enforcement actions. So they're looked at as surrogate battlefields for the real deal. And so we've been finding ways to deal with this and solutions to the problem. And I'll let someone else speak, but one of the solutions that's been identified is to encourage companies to have a set of documents, long-form contemporaneously prepared minutes, for example, that are automatic gives when you have a valid demand come in the door, rather than make frivolous objections to the demand itself. So.
Can I ask a question on the numbers? So are the numbers primarily murder cases, or are they murder cases and a huge uptick in sort of derivative investigation as well?
Right, I haven't drilled in deeply to that aspect of it, but my sense is that many of the 220 demands we're seeing are focused on derivative claims.
Okay.
So
That's consistent with my anecdotal as well, because you're not seeing all the ones that we actually do give the board stuff for.
Yes.
Yeah.
Because on deal cases, obviously, we're filing, right? You have to get them on file before the transaction closes. So I think that number is pretty clear. That the number of letters is going to match the filings, and that's just because of the ability to lose, the fear of losing standing. You're going to have to file that complaint no matter what, right? Generally, even if you're working something out. So I'm curious as to that. I think that you're right, though, that for the most part, the fights that we're having is sort of the defense bar and the corporations still not wrestling with what it is they need to give and whether or not they really want to fight on proper purpose, and whether the scope kind of issues really need to be decided at trial, as opposed to can't they really just be decided on sort of a motion to compel, sort of much more informality. And I think that's really sort of where the struggle is. And I think, again, for your docket, if there could be a way in which there is a general set, and then issues on scope don't actually have to be trial issues, but can be far more litigation type issues, just motion to compel, I think that would actually substantially lower.
Those are
the
two
heat.
separate questions, right? What do you get when you ask for documents? And there it relates back to our earlier discussion, right? If you've got a robust set of long form minutes that you can turn over and that you're willing to turn over almost automatically, right? And that answers a lot of questions about what was the process and what things were considered, right? That may be a way of sort of limiting the scope. In terms of purpose, right, that's a whole nother set of issues, right? Is this an appropriate subject for the use of inspection rights? And, you know, in the merger area, you know, we're pretty much accustomed to that. But, you know, Caremark in particular raises some, you know, pretty strong questions. Is this even a viable Caremark claim? And so do I get to sort of rummage around in the documents with respect to these issues? And, you know, where I've heard it being problematic is with respect to ESG issues in particular.
And let's be clear, no demand that's coming in just asks for board materials.
Yeah.
Like, it's asking for the moon, the sun, and the stars, and it looks like a traditional document request under litigation.
That's what
I mean, every single one.
Plenary discussion, plenary
Yeah.
proceeding. And it's, you know, I want all your emails from 2016 to present, and you know, every text message that everybody sent to their kid. I mean, it's a laundry list of 36 different categories, all broken down, and it's that's typically how I see them come in. I mean, and it's like, my purpose is to value my stock. And it's like, all right. So,
Yeah, look, the 220 is potentially ripe for some statutory change to tighten and maybe offer some more direction. That I know is under discussion in the academy and elsewhere, and you know, that's percolating up, I think, at different levels. The bottom line is, I don't think that the Court of Chancery is inclined to turn 220 into discovery. It is still necessary and essential as the driving analysis for scope. And if you can give them something meaningful that constitutes board-level documents, that's going to end it. And I think there are enough cases, even recent cases, post-KT4, Palantir, that make that point, that you ought to be able to go into boardrooms and give them that comfort. The problem is with companies that are not actually keeping even traditional, quote, board-level documents with respect to important decisions. Why? How do we know they're important? Because they're important enough for lawyers to be thinking about filing lawsuits in the Court of Chancery about them. So it's just, there's a solution to the problem. The problem is burden in these cases. The solution is get a contained set of documents that provide the rationale for the decision making and give it to them.
To circle back to your first point, though, the challenge with that, because that makes 100%, it makes so much sense. The challenge for in-house folks and directors is trying to anticipate, what do I need to do more detail in these minutes? Is to my point earlier, right? Is a reference that we talked about safety enough, or do we somehow have to build up these minutes and have them be 20 pages long so that I cover every issue that maybe 5 years from now there's going to be something to? So that, I think, is the practical, real-world challenge of trying to navigate this.
Well, that's what we call job security for you,
I mean,
Thank you, Chancellor.
anecdotally, what I will tell you is we haven't drilled down on the numbers, but I would be stunned if we found that the increase in numbers is a product of stockholders investigating direct claims relating to particularly M&A issues. I just would be very surprised if that reflects an uptick. And I know there are concerns that have been expressed about that supposedly expansion of our 220 jurisprudence, and I just don't think the numbers are there to justify that concern.
And those cases that are filed typically don't impose great burden on them either. So I think that is my impression as well.
So the VAT, we're on time, but so the real burden is on the derivative 220 using those tools, that sort of the traditional Disney tool and the
Yes, and at least on the court, that's accurate, yeah.
And I'm also mindful of the fact that when we talk about best practices in terms of preparing documents in advance, we're on the West Coast, we're talking about a range of companies, we're starting to see more derivative litigation in private companies and smaller public companies, in which the best practices may not be the standard that the board is following. And I think for counsel, right, that's going to be a real challenge.
Yeah. Well, Bluebell should be a cautionary tale. That was a privately held company. Yeah, so that is a good point, Jill.
Absolutely. Well, yes, we are out of time. The red lights were flashing, but now we're just at 0, which I think is my instruction to stop. So please join me in thanking this terrific panel, and we will move on to the next.